paragraph for the affidavit and reply of courts of law on the 6th day of June 2023. Counsel for the claimant adopted this process and urged this court to answer the questions for determination in favor of the claimant and grant relief thought. Counsel for the defendants, responding to the originating summons, identified an 18-paragraph counter affidavit deposed to by one famous Dix and filed on the 19th day of June 2023 and attached with the counter affidavit are exhibits A to J. The defendant also filed a written address in opposition to the summons and urged this court to dismiss the suit. The fact as contained in the affidavit in support of the originating summons is that the claimant worked as a state counsel with the Bayelsa State Ministry of Justice and a deputy director at the time of operation of this originating summons. The claimant will be due to exit as the head of the Ganishi Unit Ministry of Justice from the service of Bayelsa State on the 16th day of November 2022. The claimant holds its certificate in education, NCE, and became employed to the teaching service of River State Post-Primary School Board as a classroom teacher in 1990. That the claimant's employment to the then River State, out of which Bayelsa was created, was made in the year 1990. That the claimant, while serving as a teacher under the then River State, had official permission to continue the sandwich program commenced before the employment in 1990 at the University of Port Harcourt, where he obtained a bachelor's in education in 1992. That the claimant continued in the service until Bayelsa State was created in 1996, when it inherited all the civil servants of the state from the River State. Upon the claimant was also inherited to serve under the Bayelsa State government, to be under the control and management of the Bayelsa State Primary Schools Board, and integrated and transferred to Ministry of Justice under the control and management of the Civil Service Commission set up by the state. That before the claimant's integration and transfer, he was a vice principal and due for grade level 13. But the claimant's service is due for grade level 17 in 2018, in line with the order of progression contained in the public service rules. That while the claimant was integrated and transferred to Ministry of Justice, he was stepped down by 2 grade levels, using 9 years in the service and career as a civil servant. That the claimant was offered the letter integrating him to Ministry of Justice on the 7th day of September 2004 as a senior state counsel on salary grade level 10. The 2 other officers were integrated the same period with the claimant, that is Boniface Agulata and Ezoha Borodi, who were on grade level 9 from the same post-primary department, and they were integrated with the promotion to grade level 10, while the claimant was stepped down from level 13 due to him to start from level 10. That the claimant had put in of several letters corresponding to the Civil Service Commission protesting the undue placement and stepped down in line with Chapter 9, Section 1, Subsection 090101, Subsection 2 of the Public Service Rules timeously and consistently, last being 17th February 2022, and forwarded on the 20th day of April 2022, routed through the Ministry of Justice. So I will skip this because I have other judgments to write to deliver. Sorry, please, when you get the ruling, look at it very well. So let me go to the counter affidavit filed by the defendants. It is that sometimes in 2003, the claimant made an application to the 3rd defendant for transfer of his service from Bayelsa State Post-Primary School Board to the Ministry of Justice. After inquiry from the consultation with the Ministry of Justice, the 3rd defendant notified the claimant that the available vacancy was the state counsel on grade level 10 and offered that the claimant voluntarily accepted. That the claimant's account of his career progression after his 2004 transfer to Ministry of Justice, that his progression ought to be as state counsel grade level 10, 2004, principal state counsel grade level 12, 2007, assistant chief state counsel grade level 13, 2010, chief state counsel grade level 14, 2013, assistant director grade level 15, 2016. However, due to inadvertence, he was promoted as state counsel grade level 10 in 2004, principal state counsel grade level 12, 2006, assistant chief state counsel grade level 13, 2009, and chief state counsel grade level 14, 2012, and assistant director grade level 15, 2015, and deputy director grade level 16 in 2019. that this inadvertence, that is the claimant's failure to complete a minimum of 3 years before moving from grade level 10 to grade level 12, was discovered when the claimant presented his application and documents preparatory to his retirement from service, that except in cases of special promotion by Rule 020607P, Public Service Rule 2008, the minimum number of years an officer on grade level 15 should spend before being promoted to the next grade level is 2 years. That the defendant as the body vested with the power of appointment, confirmation, promotion, discipline, and retirement of civil servants has the power to effect permanent or temporary transfer of desiring officers in the state civil service of the state. So I will jump and then I'll go to the decision of this court. I have carefully analyzed all the processes filed before this court. It goes without saying that this suit is commenced by an originating summons under 3 and 17 of the rules of this court. It is known that the originating summons procedure is used whenever the law so provides, and when the issues or issue in question are or are likely to be issues of construction of the written law or any instrument of any deed, will, contract, or other document or other question of law, or in a circumstance where there is not likely to be material dispute as to the facts, where it is likely that the facts in the suit will be contentious and materially contradictory. It will be inappropriate to commence the suit by way of originating summons. Such a suit is to be commenced by writ of summons. See the case of Jimo against Olawale, Ekanem against registered trustees of CCGS, reported in 2023, 6 NWLR Part 1879 at page 43. Admittedly, the law does not envisage that a suit commenced by originating summons must be devoid of dispute. After all, there cannot be a cause of action without a tribal disputed fact. It is a dispute that makes a case, but the dispute expected to be made for the suit commenced by the originating summons must be such that can be resolved by the construction of written laws or documents, not the one that will require the calling of witnesses. The Supreme Court in the case of Sani against Kogi State House of Assembly, citing the case of Ram against Mohammed, the Supreme Court held, and I quote, "It is not the law that once there is dispute of facts, the matter should be commenced by writ of summons. No, that is not the law. The law is that the dispute of facts must be substantial, material, affecting the live issues in the matter. Where disputes are peripheral, not material to the live issues, an action can be sustained by originating summons. After all, there can hardly be a case without facts. Facts makes a case, and it is the dispute in that facts that gives rise to litigation," unquote. In this instant case, it is not in dispute that the claimant started his career as a classroom teacher in 1990. The claimant immediately before he was integrated into the mainstream civil service was on grade level 12, and the claimant was integrated into the mainstream civil service on grade level 10, attached to the Ministry of Justice. The reduction in the grade level of the claimant forms the basis of this suit. This suit becomes hostile and contentious when the defendant stated that the claimant was a new wig at the time of his transfer to Ministry of Justice, which makes the Ministry of Justice to place the claimant on the entry level of grade level 10. There is need for evidence to establish when the claimant was called to bar as barrister and solicitor of the Supreme Court of Nigeria, and whether the Ministry of Justice could reckon with the claimant's years of experience from 1990 to 2004. The claimant further stated that a committee was set up to review the salaries and promotion of all civil servants in the state, recommended that the claimant be promoted to grade level 17 before his retirement. Defendants joined issue with the claimant, asserting that it is not the duty of special wages and salary review committee set up by the government to recommend the promotion of the claimant. No terms of reference was placed before this court to ascertain the frontier of the duties of the committee. Neither was there any document evidencing the recommendation of the special wages and salary review committee. Hence, this calls for evidence. Against the defendant raised the issue of the deadline for the submission of APA form. That the deadline for the submission of annual performance evaluation report APA form during the 2022 promotion exercise was 17th June 2020. However, claimant's APA form was submitted on the 24th day of June 2020. So the third defendant acted within its power to reject the said. No circular stating the deadline for the submission of APA form was placed before this court. The issues raised above, The issues I raised above are very germane for the determination of dispute. There is no documentary evidence before this court to reconcile these hostile facts. Hence, it is imperative for the parties to exchange pleadings. The form of commencing an action is never fatal in the sense that it does not make the action incompetent. In other words, it does not matter whether an action is begun by writ of summons or originating summons. The important consideration always being justice of the case. So, when a suit is commenced by originating summons instead of writ of summons, the appropriate order to be made by the court is to direct the suit to proceed with the filing of pleadings. See the case, strong case of Igwe against Lokaka, quoted in 2023, 1 NWLR Part 1865. This position of the law is in consonance with the provision of Order 317 of the rules of this court, which state that where, in the opinion of the court, a suit commenced by originating summons raises substantial issues and disputes of the court shall not strike out the matter, but may order its conversion to complaint and direct parties to file and exchange pleadings and conduct the trial case in accordance with the rules of court government. Given the reasons I stated are foregoing, I hereby order parties to exchange pleading for the proper trial of this case. I order that this file be returned back to the Yenagoa Division of the National Industrial Court for adjudication. Our ruling is hereby entered accordingly.
As the court pleases.
Yes.
We are very, very grateful, my lord.
Thank you, Table. That's the next one.
Number 2, NICN/Yenagoa/28/2018 between Mr. Company Pluto, the 3 others, and Ale Brown, a Fuller Consortium is another.
Yes, representation. The case of company against Harley Brown Consortium.
My lord, with
yes.
profound respect, my lord. I am IRZ.
Yes.
Gedu is spelled IGEDU, my lord.
Yes.
My lord, I appear for the claimant.
Yes. Defendants not represented.
Absented. Check by absented.
Company Odo, defendants not represented.
Okay, but just check.
My lord, I don't see them around.
Okay. This is the judgment of the court. By the complaint filed pursuant to the 3.2 of the rules of this court on 19th July 2018, whereas the claimant claims against the defendants the following reliefs. A declaration that the claimants, all of whom are in the employment of the first defendant as security personnel, based on the first defendant contract with the second defendant without payment of salary from the month of January 2013 to date, is unlawful and amounts to breach of claimant's respective letter of contract of employment. An order directing defendants, whether jointly or severally, pay to each of the claimants damages in the sum of 1,980,000 naira only, being salary accruable to each of the claimants from the month of January 2013 to June 2018 at the rate of 30,000 naira per month. an order directing the defendants, whether jointly or separately, to pay to each of the claimants damages in the sum of 600,000 naira, being bonus accruable to each of the claimants for the year 2013 to 2017 at the rate of 120,000 naira, and also from 2018 and subsequent years until judgment is entered. The claimants predicated their claims on the statement of facts and witness statement of oath filed on the 17th July 2018, and the reply to the second defendant filed on the 29th day of March 2019. The first defendant, despite being served with the originating process and hearing notices, did not file any process, neither was it represented throughout this trial. The second defendant, upon being served with the complaint, filed an amended statement of defense and a witness deposition both on the 27th day of December 2018. The second defendant incorporated counterclaim in its defense and seek the following relief against the claimants as follows. Whereof the second defendant counterclaims against all the claimants jointly and severally the sum of 2 million naira being the cost of defending the suit. The suit proceeded to hearing on the 19th day of February 2020. Claimants called a Su Ekwehi, hearing after refers to as CW1. CW1 identified the statement of oath made on 19th July 2018, and same was adopted as its evidence in chief. The claimants further called Omodi Otuare, hearing after refers to as CW2. CW2 identified his deposition of oath made on 24th February 2021. Exhibit CW001 to 3 were attended and admitted by this court in evidence. The second defendant opened its defense on the 9th day of February 2023. The second defendant called Babatunde, Mr. Babatunde Obi, hearing after refers to as DW1. DW1 identified his deposition of oath made on the 27th December 2018. The same was adopted as his evidence in chief. On the 25th day of October 2023, matter came up for adoption of final written address. Counsel for the second defendant identified the final written address filed on the 10th July 2023 and adopted same as his legal submission in support of the case of the second defendant and urged this court to dismiss the case of the claimants. While deliberating on this address, the second defendant submitted that the deposition on oath filed by the claimants do not comply with Section 13 of the Oath Act, and there is no evidence in support of the case of the claimant. Counsel referred this court to the case of GT Bank PLC against Abiodun. Counsel for the claimants also identified the final written address filed on the 10th day of July 2023 and adopted same as legal submission in support of the case of the claimants and urged this court to grant the claims of the claimants. Let me briefly state the claim of the claimants. The process of the case of the claimants is that the claimants are employees of the second defendant. The first defendant is an agent of the second defendant. The first defendant is an agent of the second defendant, which provides security personnel and other services at the Uzeri NGC station, which is under the use and control of the second defendant. And the second defendant is a current operator, OML 30, which was set up to previously operated by the Nigerian Petroleum Development Company, NPDC. That some years ago, the Nigerian National Petroleum Development Company, NPDC, acquired from Shell Petroleum Development Company, SPDC, OML 30, for the second defendant took over from Nigerian Petroleum Development Company, sometimes in March 2017. That sometimes in 2008, they were employed by the Shell Petroleum Development Company, which has been now acquired by the second defendant. That their employment was through the first defendant as an agent of Shell Petroleum Development Company, and they are issued a separate letter of contract of employment. That the operator of OML 30, through the first defendant as agent, employed individuals, including the claimants as security personnel and housekeepers in the entire field covered by OML 30. That they are employed as security personnel on a monthly salary of 30,000 naira to guard the premises of Nigerian Gas Company, Uzeri, now in possession of the second defendant, and that they were regularly remunerated until NPDC acquired interest in OML 30 in Shell Petroleum Development. And that ever since NPDC came on board, up to when the second defendant acquired OML 30 from NPDC and afterwards, the claimant have been denied their wages or salaries by the defendants from the month of January 2013 to date. That their contemporaries in Afuseri Eriamu, Ebreni, Owe, Olomoro, Ohe, Oroni, Osioka, Apollo, are still in their employment and are well remunerated to date. That notwithstanding their unpaid salary, they have continued to perform their responsibilities under their respective contract of employment to the knowledge of the defendants, whose officials visit the premises of Nigerian gas company Uzeri on a regular basis. That in accordance with the tenure of their respective letter of contract appointment, they are to pay bonuses for 120,000 naira per year in the month of December in every succeeding year from 2008 to 2012, in accordance with their respective letter of contract of appointment. That they have not been placed or relieved of their duties created under their respective letter of contract of employment. Neither have they been notified orally or in writing by any notice that no pay or benefit was ever paid to them, to suggest that their services were letter of contract of employment at the time, that they have not waived their right to be notified of the termination of their letter of contract of employment, whether orally or in writing, or from accepting any payment or salary in lieu of notice. That fell on but the second defendant to have enumerated the claimants of their wages as occasioned them, and indeed their respective immediate families. The brief case of the second defendant is that the second defendant stated that the claimants are not employees of the second defendant, that he does not know how any of the claimants, and at no point in time were the claimants ever employees of the second defendant, that he does not know the first defendant and has never done any business with the first defendant. The Shoreline Natural Resources Limited acquired Shell Petroleum Development Company in participatory interest in OML 30, while Nigerian Petroleum Development Company, NPDC, took over operatorship from SPDC. That the second defendant never acquired Shell Petroleum Company. That it is not in the position to deny or admit the claimant's employment status with SPDC, as those facts are only known to the claimants, who have never been employees of the second defendant. That the second defendant took over operatorship of OML 30 from NPDC. That before its appointment as operator of OML 30, it carried out its due diligence to verify all pending contracts, including recruitment contracts and staffing of NPDC, and neither the claimants nor the first defendant had any existing employment or contract with them. That upon its appointment as operator of OML 30, NPDC did not novate any employment contracts with the claimant. The counsel for the claimants nominated two issues for determination of this suit, to which A, whether from the totality of the evidence before the court, the claimants are in employment of the second defendant, who is the operator of OML 30. Secondly, whether claimants having been keeping watch over the premises of the second defendant from 2013 to date, to the knowledge and concurrence of the second claimant, are therefore entitled to payment of wages. And second defendant nominated three issues for the determination of this suit. First, whether facts and evidence presented by the claimants have established an employer-employee relationship with the second defendant. And secondly, whether from the evidence before this court, the claimants are entitled to judgment against the second defendant. And then thirdly, whether the second defendant is entitled to its counterclaim. Having carefully gone through the processes filed by parties in this suit, I'm inclined to adopt the issues nominated by the second defendant for the determination of this suit. The three issues nominated by the second defendant are hereby adopted accordingly. I will skip your legal arguments. You know what you presented to me. So when you receive the judgment, read your submission. So I'll go to the decision part now. I have carefully considered the processes filed by both parties and the evidence adduced before me. Before going into the merit of this case, it is legally imperative to do the house cleaning of the issue of the validity of the deposition of oath of CW1 and CW2 adopted in the course of the proceedings of this court before going into the merit of this case. The second defendant argued that the deposition of oath of CW1 and CW2 do not comply with Section 13 of the Oath Act. The claimant submitted that the contestation of the second defendant is a mere irregularity. Though counsel for the second defendant did not specifically point out the offensive part of the deposition of oath of CW1 and CW2, but I have carefully gone through the said depositions of oath of CW1 and CW2 that were adopted by the claimants as evidence in chief on the 19th day of February 2020 and 14th day of October 2020. The omission I notice from the said deposition on oath is the statutory declaration, which usually reads as follows, and I quote, I do solemnly and sincerely declare that the set out numbered paragraphs that I make this solemn declaration, essentially believing the same to be true and by virtue of the provisions of the Oath Act. The provision of, unquote, the provision of Section 13 of the Oath Act as amended 2004 provides, and I quote, it shall be lawful for any commissioner for oath, notary public, or any other person authorized by this act to administer an oath, to take and receive the declaration of any person voluntarily making the same before him in the form set out in the first schedule of this act, unquote. Without adulterating the provision of Section 13 of the Oath Act quoted above, the Act does not render an affidavit which does not contain statutory declaration void. It merely provides for the persons who can validly administer the oath on the affidavit. When it comes to the issue of validity of an affidavit, the provision of the Oath Act and the Evidence Act are the principal statutes that will be considered. It is important to note that the deposition under the consideration are not attacked on the basis of Section 115 of the Evidence Act. Neither was it attacked on the ground that the depositions were not commissioned or signed before the authorized person signed by this court. The fundamental condition for an affidavit to be valid is the swearing on oath before the commissioner for oath. It is on this vein that the provision under the Oath Act becomes relevant. A defect as regards the swearing on oath is not a mere irregularity as to form, but defect as to substance. See the case of Olubaje against Idris, citation provided. Assuming without agreeing with the submission of the learned counsel for the second defendant that an omission of the statutory declaration in the deposition on oath of CW and CW2 is capable of rendering the deposition on oath void, the provision of Section 109 of the Evidence Act 2011 is a succor to cure the defect in an affidavit that does not go to the substance of the affidavit. Deposition of CW1 and CW2 in this instant case. In the case of Atai Farms Limited against NSCB Limited, quoted in 2003, the Court of Appeal held, and I quote, furthermore, Section 84 of the Evidence Act empowers the court to permit an affidavit to be used, notwithstanding the affidavit is defective in form according to the Evidence Act. Section 84 of the Act provides that the court may permit an affidavit to be used, notwithstanding it is defective in form according to this Act, if the court is satisfied that it has been sworn before a person duly authorized. There is no complaint that the said affidavit was not sworn before a duly authorized person. To my mind, there is no defect in the affidavit, and if there is any, such a defect has been saved or cured by Section 84 of the Evidence Act. In the circumstances, I'm of the view that the learned trial court was right when in consideration of the case it attached with to paragraph 2 of the said affidavit, unquote. In addendum to the exposition of the law, in the case of Uduma against Awusi, it's a 2012 case, the court held, and I quote, from the law and judicial interpretations given, one is bound to agree with the learned tribunal that the senior counsel for the respondent that the defect in the form of written statement, once is sworn before a person duly authorized, is a mere irregularity which cannot affect the jurisdiction of court since it cannot invalidate the performance of official duty. Unquote. Given the above statutory and judicial authority cited hearing, an omission of the statutory declaration in the deposition on oath of CW and CW2 already adopted by this court will not vitiate the deposition on oath of CW and CW2. Thus, the deposition on oath of CW and CW2 are valid and will be relied upon in considering the merit of this case. The objection raised by learned counsel, the second defendant, is hereby discountenanced. And I so hold. Issue 1, let me now come back to the merit of this case. On issue 1 nominated by the second defendant, which has been adopted for determination of this case, given the pleading and evidence before this court, it is not a dispute that it is not in dispute that the first defendant is the recruitment agent of Shell Petroleum Development Company, gleaning from exhibit CW001 and CW003. The claimants were employed by the first defendant for the use of Shell Petroleum Development Company at OML 30, which parties herein referred to as OML 30. There is a case of an agent and a disclosed principal here. The disclosed principal, not the agent, is liable for the act of the principal. An agent acting on behalf of a known and disclosed principal incurs no liability. This is because the act of the agent is the act of the principal towards the principal who did or omitted to do what the agent did or omitted to do. The common law is expressed in the Latin maxim, qui facit per alium facit per se, a sum in therefore, which means he who does an act through another is deemed allowed to do it himself. An action against an agent in its private capacity for acts done on behalf of a known and disclosed principal is incompetent. See the case of Federal Republic of Nigeria against Shogun Nigeria Limited and UBA PLC against Okunda. In this instant case, it is Shell Petroleum Development Company which used the service of the claimant as its O and M as contained in exhibits CW001 and CW003, thus making the first defendant a party to this case is a mere cosmetic. The claimants pleaded at paragraph 7 of Statement of Fact that the new operator of OML 30, where the claimant was stationed, guard is the second defendant. However, the second defendant pleaded that Shoreline Natural Gases Limited acquired Shell Petroleum Development Company Limited participatory interest in OML 30, while Nigerian Petroleum Development Company, NPDC, took over operatorship from SPDC. That the second defendant never acquired Shell Petroleum Development Company. That the second defendant took over operatorship of OML 30 from NPDC. Given the nature of the claim of the claimants, the claim of the claimants borders on who is responsible for the payment of their salaries, not who acquired OML 30. From who the second defendant acquired the operatorship of OML 30 does not matter. Whether from Shell Petroleum Development Company, Nigerian Petroleum Development Company, or Shoreline Natural Resources Limited. What is important to discuss is who is in charge of operation of OML 30. Inasmuch it has been established that the claimant had a contract with Shell Petroleum Development Company to guard OML 30, and the second defendant by its admission took over the operatorship of OML 30 from Nigerian Petroleum Development Company. The fact of who is in charge of the operation of OML 30 is not in dispute and needs no further proof. Proof presupposes an existing dispute. Therefore, once there is an admission of the fact, issues are not joined as far as the fact admitted are concerned, and no proof becomes a surplusage or a superfluity. What is admitted needs no further proof. See the case of Menekaya against Menekaya. From exhibit CW001 and CW003, the claimants were severally employed to guard OML 30. The second defendant later took over the operatorship of OML 30 from Nigerian Petroleum Development Company. The defendant inexplicably failed to lead evidence to show that the contract of employment between ASPDC with the claimants had been terminated. Thus, failure to lead evidence to establish the cessation of contract of employment between the claimants and SPDC implies that the contract of employment of the claimants to guard OML 30 subsumes the operatorship of OML 30. The court is not unaware of the doctrine of privity of contract raised by the second defendant in its address. Privity of the contract is the relation between parties in a contract, while entitles them to sue each other, but prevents a third party from doing so. Thus, the doctrine of privity of contract is all about the sanctity of contract between the parties to it, and it does not extend to others from outside. See the case of Nospetco Oil and Gas Limited against Urumbe. It's a 2022 case citation provided. See also the provision of Section 91 sub 1 of the Labour Act and the case of Sherna Security Company Limited against Apple Park. The principle of privity of contract is not without exception. Premised on evidence before this court, the claimants were employed to guard OML 30 by Shell Petroleum Development Company. The second defendant later took over the operatorship of OML 30. The second defendant will not lead evidence to show that the employment of the claimants to guard OML 30 is terminated. Neither did the claimant lead evidence to establish that the claimant did not guard OML 30. The second defendant who has benefited from the service of the claimants cannot now turn back to raise a defense of privity of contract. Thus, the defense of privity of contract cannot exculpate the second defendant from the claim of the claimants. It is therefore the finding of this court that there is a tacit employment relationship between the claimants and the second defendant. Issue 1 is hereby resolved in favor of the claimants, and I so hold. On issue 2, which borders on whether the claimants are entitled to the judgment of this court, the claimants pleaded and laid evidence to establish that they were employed as security personnel to guard the premises of Nigerian gas company Uzeri, now in possession of the second defendant, that the claimants have been denied their wages by the defendants from the month of January 2013 to date. DW1 under cross-examination stated one of the facilities of the second defendant is in Uzeri in Delta State. DW1 further stated that he has never visited Uzeri, that he knows that there are security personnel at the second defendant's facility at Uzeri. This piece of evidence elicited under cross-examination from DW1 is rather in support of the case of the claimants. DW1 has never been to Uzeri, where OML 30 is situated. DW1 is aware that there are security personnel who guard OML 30 at Uzeri, but could not mention the names of those personnel who guard OML 30 at Uzeri. This piece of evidence concretized the case of the claimants. Cross-examination is part of trial proceedings, and the answers elicited thereunder are given on oath. Consequently, where the answers elicited under cross-examination are relevant and direct to the issue, they will be given due probative value and will not be brushed aside simply because they came through cross-examination. See the case of Ogwede against Osula. To further strengthen the case of the claimants, Exhibit CW002 was addressed to the managing director of the second defendant and delivered to the office of the second defendant via a logistic company, Red Star Express. Though the second defendant denied receiving Exhibit CW002, but the claimants through CW2 further mentioned the name of the member of staff of the second defendant, Lemon O, who received the service of Exhibit CW002. Denial of the second defendant is not enough to disprove the service of Exhibit CW002. And the second defendant ought to have cross-examined the CW2 on the service of Exhibit CW002. The noble art of cross-examination constitutes a legal well form in the hands of the adversary to enable him to demolish the case of the opposing party. It is therefore good practice for counsel not only to put across his client's case through cross-examination, he should, as a matter of utmost necessity, use the same opportunity to negative credit of the witness whose evidence is under fire. See the case of Ofedayu against the state. Therefore, failure of the second defendant to respond to Exhibit CW002 amounts to admission. The law is that where a party failed to respond to a business letter, which by nature of its content requires a response or rebuttal of same, the party will be deemed to have admitted the contents of the said letter. Therefore, where a bank makes a demand for settlement of debt by letters and the amount of debt is contained in each letter, and the debtor does not query the respective letters as the overall debt due, debtor will be deemed to have impliedly admitted the quoted figures as the amount of debt due. See the cases of Tiligado and Co. Nigeria Limited against Access Bank, Bagobiri against Unity Bank PLC, Boni against Ebule, Bellevue Airlines Limited against Fadaunsi, Onigbo against Azubuke, Niger Aluminium Manufacturing Company Limited against Unioba. All citation provided. Given the gamut of evidence before this court, issue 2 is hereby resolved in favor of the claimants, and I so hold. Lastly, on issue 3, which borders on counterclaim. First of all, cost incurred by a party to defend itself cannot form a basis for a counterclaim. Counterclaim is a separate suit on its own. A counterclaim relief should not be a relief grantable by judicial discretion, but award of cost of litigation is granted subject to the discretion of the court, though the discretion will not be exercised arbitrarily. Again, there is no fact in support of the counterclaim of the second defendant. Thus, I see no reason why the second defendant should be seeking a counterclaim where there is no pleading and evidence to assess the claim of the second defendant. In the case of DHL International and Nigeria Limited against Eze Uzomaka, reported in 2020, 16 NWL Part 1751 at 442, the Court of Appeal held that cost of litigation must be pleaded and instant case there is no evidence by way of lawyer's fee not, bill, or payment of same or expenses placed before the court in regard to the cost of litigation by the second defendant. Thus, the grant was out of sync with the findings of one of proof of the cost. Issue 3 is hereby resolved in favor of the claimants, and I so vote. In all, the claim of the claimant succeeds against the second defendant premise on the following grounds. A, the claimants were employed by SPDC to guard OML 30. B, the second defendant later took over the operatorship of OML 30, and there is evidence before this court that the employment were not terminated after the second defendant took over the operatorship of OML 30. C, it is in evidence before this court that there are security personnel guarding OML 30 at Uzere, but the second defendant could not give the particulars of those who were guarding the OML 30. And D, the first defendant is an agent of a disclosed and non-principal, so the first defendant could not be liable to pay the claimants their salary. Flowing from the foregoing as enumerated ab initio, the court grants all the reliefs of the claimants in the following terms as follows. I declare that the claimants, all of whom are in employment of the first defendant as security personnel, based on the first defendant contract with the second defendant without payment of salary from the month of January 2013 to date is unlawful and amounts to breach of claimants' respective data of contract of employment. I order the second defendant to pay each of the claimants damages in the sum of 1,980,000 naira, agreeable to the claimants from this month of January 2013 to 2018 at the rate of 30,000 pounds. I order the second defendant to pay each of the claimants the sum of 600,000 naira, being equivalent to each of the claimants for the year 2013 to 2017 at the rate of 120,000 naira per year. All terms in this judgment are to be complied with within 30 days from today, without prejudice, right of appeal by any party who feel dissatisfied with the judgment of this court. I decline to award any cost, and judgment is hereby entered accordingly.
As the court pleases. My Lord, we are very, very grateful for my Lord's industry and for that flawless judgment. We are very grateful, my Lord.
Thank you. Yes.
Case number 3, NICS/Yenagoa/16, 2022, Mr. Udiwi Lawson and Dallon Oil and Gas Company Limited.
Present.
Claimant present.
Yes, my Lord.
Yes, representation.
With the humility of this honorable court,
Yes.
my Lord, I'm S.Y. Dombo.
S.Y. who?
Dombo. G-U-M-B-O, my Lord.
G-U-M-B-O. G-U-M-B-O.
Yes, my Lord.
Yes.
My Lord, with me are my learned friends. N-E-Etam.
N-E-Etam.
Yes, Etam is spelled I-T-A-M.
Yes.
And D-M Dombo.
Yes.
Our humble appearance is for the claimant, my Lord. We are grateful.
Yes. Defendant. Defendants not represented. Yes.
Perepuye Biware.
Biware.
Perepuye Biware.
P. Biware.
Yes, my Lord.
Yes.
With me is my learned friend, Easy.
Yes.
My Lord, we are for the defendant.
Sorry. Sorry for the technical hitch. Can you hear me? Can you hear me?
We can hear the court, my lord.
Yes. Sorry for the technical hitch. This is a judgment of the court. The claimant commenced this suit by way of complaint filed on the first day of June 2022 under Order 3, Rule 2 of the rules of this court, whereas the claimant claims against the defendants the following reliefs: a declaration that the claimant is a surveillance worker of the second defendant, a declaration that the claimant is entitled to a monthly salary of 750,000 naira only, an order directing the defendants jointly and severally to pay to the claimant the sum of 12,750,000 naira only as a salary arrears from April till the filing of this suit. An order directing the defendants jointly and severally to pay to the claimant the sum of 750,000 naira monthly as monthly salary from the date of filing this action till judgment is delivered. An order directing the defendant jointly and severally to pay to the claimant a sum calculated at 15% per month as interest of the total judgment debt till judgment is liquidated. General damages at the sum of 50 million naira. The claimant predicated his claim on the statement of facts and witness statement on oath filed on the first day of June 2022 and reply and a further witness deposition on oath filed on the 7th day of October 2022. The defendants based their defense on a joint statement of defense and witness deposition on oath filed on the 4th day of July 2022. At the plenary hearing on the 24th day of October 2022, where the claimant called his first witness, Mr. Sobite Angasi, who testified for the claimant, hearing after referred to as CW1, who identifies his deposition made on oath on the first day of June 2022 and adopted same as his evidence in support of the case of the claimant. On the 25th day of January 2022, the claimant hearing after referred to as CW2 testified for himself as CW2 identified his deposition on oath, which was made on the first day of June 2022 and 7th day of October 2022, and adopted same as his evidence in support of this case. After tendered CW001 A and B. On the 13th day of June 2022, the defendant opened their defense. Mr. Tarakri Oboin, hearing after refers to as DW1, testified for the defendants. DW1 identified his statement on oath filed on the 4th day of June 2022 and adopted same as his evidence in support of the defendant's defense. On the 19th day of July 2023, Mr. Samuel Ombu, who testified for the defendants, hearing after referred to as CW2, identified his depositions made on oath on the 4th day of July 2022 and adopted same as his evidence in support of the case of the claimant. Counsel for the claimant identified his final written address filed on 29 November 2023. After the close of hearing of the suit on the 4th day of December 2023, matter came up for adoption of final written address filed by counsel. Counsel for defendants identified his written address filed on the 31st October 2023 and reply on points of law filed on 4th November 2023 and adopted same as his legal submission in the aid of the case of the defendants and urged this court to dismiss the suit. Counsel for the claimant identified his final written address filed on 29 November 2023 and adopted same as his legal submission in the aid of the claimant's case while urging this court to grant the claims of the claimants. Let me briefly state the case of the claimants in brief. The claimant stated that the subject matter of this suit is the failure or refusal of the defendants to pay his monthly salary as a surveillance worker for ever a while without any form of explanation while he is still in the employment of the defendants. That sometimes in May 2014, the third defendant, David Leon, called him and directed that he should go to FMC Waterside and meet one Ray Osakwe. That upon reaching the said FMC water side, he met Honorable Ray Osakwe with Sue, Bite, Angasi, and others inside 3 fiber boats. That Honorable Ray Osakwe asked him on arrival to enter one of the fiber boats. Can you hear me? Can you hear me?
My lord, we can hear you.
Okay.
My lord, we can hear you too.
Enter one of the fiber boats, which he did when they moved to Ologbobri in the southern Ijo local government area of Bayelsa State. That on getting to Ologbobri, he called the third defendant, David Leo, who informed him of their arrival. And then the third defendant said on phone in reply that he, the claimant, is his eye in the job. That he then asked what kind of job. The third defendant said over the phone in their conversation that it was to stop illegal oil bunkering activities, that they work as a team, and for 6 months they are not paid. But it was on the 7th month that the Ajib Oil Company awarded the oil and gas surveillance job contract to a defendant to secure their facilities. That then Honorable Ray Osakwe was an advisor to the then Southern Regional Local Government Chairman on oil and gas matters. That then the Southern Regional Local Government Council was collaborating with the defendants in curbing illegal bunkering activities in the local government area. That the third defendant, David Leon, called him, the claimant, to meet him at his house at Ibogin, Yenagoa, which he did. That upon reaching the third defendant's house, residence at Ibogin, he was asked by the third defendant to give his company incorporation documents and the DPR approval, which he did. That the third defendant promised he was going to introduce him, the claimant, to the general manager, Nigerian Ajib Oil Company Limited. That the details of his company, which he gave to the third defendant, is Ebwe Jacks Laws. That at the end of the third defendant never introduced him to the general manager, Nigerian Ajib Oil Company, nor was his company given any contract, but he ended up working as a surveillance worker in the second defendant. That at the end of the 7th month, the third defendant said the claimant with other workers of his company and sent one Mr. Tonye Ekere Duare in the company of a banker, a staff of UBA, to the village Ologbobri in southern Ijo local government area of Bayelsa State for all the workers to open an account with UBA, wherein their salaries were paid directly from the second defendant. That before they open an account with the UBA, they were paid cash at hand by Honorable Ray Osakwe for over 1 year. That after the second defendant paid the salary to Honorable Ray Osakwe for over a year, the second defendant paid his monthly salary to one Mr. Liba Wilson for a while. That it was at the end of the second defendant paying the salary to Liba Wilson that Mr. Tonye Ekere Biware came to the village with the UBA PLC staff account opening forms for all categories of workers to open accounts for payment of monthly salaries. That after opening the individual account, he transferred the individual account, he started receiving his monthly salary from the second defendant through his UBA individual account domiciled with the UBA PLC till April 2020, when he has not been paid his monthly salaries without any form of notice or explanation or reason given. That he was initially a field worker with others till sometimes in the year 2016, when the third defendant called him to his house in the village and asked the claimant to leave the field work and take charge of the fuel department as a fuel clerk recorder by way of the deployment. That since then he has been working at the fuel department as a fuel clerk recorder till the filing of this action. That the defendants are owing him 21-month salary as of January 2022. The defendants briefly in their statement of defense stated that the claimant has at no point in time been under the employment of the defendants. That the first and second defendant had a surveillance contract with Ajib Oil Company Limited to secure its oil and gas pipelines, among other oil facilities, which job the first and second defendant executed through the use of the military, Nigerian Security and Civil Defense Corps, and Nigerian Police. That during the operations in the execution of the aforementioned contract, one Levi Wilson was contracted on a yearly basis for the purpose of distribution of fuel, PMS, and engine oil into the speedboat used for the operation by the military, civil defense, and the Nigerian police. That Levi Wilson needed some boys or men to work with him in the distribution of the PMS. Hence, Samuel Umbu was brought together with Mr. Godwin Gideon to help him turn the fuel into the speedboats, while the third defendant brought in Mr. Odi Lion and the claimant being his younger brother to assist Mr. Levi Wilson for a monthly allowance, while the claimant was paid other money to reach out to members of the third defendant family who are also members of the claimant's family. That the claimant, Mr. Samuel Umbu, Mr. Godwin Gideon, and Mr. Odi Leon were all told about their allowances, and they will only be engaged during the period of the first and second defendant contracts with the Nigerian Oil Agent Company, and were placed on a sum of 70,000 naira only as monthly allowance each, where the claimant was given additional 620,000 naira monthly to be given to family members of the claimant and the third defendant. That it was when their contract was terminated by the Nigerian Agent Oil Company Limited that the claimant and others stopped receiving their monthly allowances. That the claimant, even if gainfully employed by the defendant, will not be paid the sum of 750,000 naira only as a salary, as he is not a professional that is specialized in any area of oil and gas. That the defendant did bid for a surveillance contract with the Nigerian Oil Agent Company Limited, but denied the fact that the claimant was paid salary as an employee of the defendant. The third defendant placed the name of the claimant on the monthly payroll of the second defendant because the claimant is the younger cousin to the third defendant, who he sent errand most time to enable the claimant meet his needs and other family members, but denied the fact that the claimant was employed by the defendants in any official facility. At the close of the party's case, counsel for the claimant nominated a sole issue for determination of the suit, to wit, whether from the evidence and the circumstance of this case, the claimant has proved his case and therefore entitled to the relief sought. Counsel for the defendants nominated 4 issues for determination of the suit, to wit, 1, whether or not the claimant has successfully established that there is an employer-employee relationship between him and the defendants, the circumstance of this case entitling him to the relief sought. Secondly, whether or not the claimant is entitled to the cumulative amount of monthly salary claimed from the defendants. Thirdly, whether or not the claimant's failure to deny or respond to the facts in paragraph 6 of the defendant's joint statement of defense and failure to cross-examine the defendant witnesses on such material facts constitute admission of those facts stated therein. And fourthly, whether or not the claimant has proved his case on the balance of probability as to entitle to the relief sought in this case. Having holistically given this claim of the claimant due consideration, the claim of the claimant centered on the existence of the employment relationship with the defendant and a claim for payment of unpaid salaries. That being so, issue 1 and 2 have covered the central issue of the claim of the claimant, though issue 3 raised by the defendants will be considered in the course of evaluating evidence before this court, while issue 4 is a replication of issue raised in issue 1 and 2, and needless after. The resolution of the court, the case of the claimant, will determine whether the claimant is entitled to relief sought. Therefore, the court is inclined to adopt issues 1 and 2 as raised by the defendants because they are apt, concise, and all encompassing to address the claim of the claimant. For the sake of clarity, the issues for determination before this court are here under reproduced as follows. 1, whether or not the claimant has successfully established that there is an employer-employee relationship between him and the defendant. And secondly, whether or not the claimant is entitled to the cumulative amount of monthly salary claimed from the defendants. I will skip your arguments as contained in the final written addresses, and I will go to the decision section of this judgment. So, court decision. I have carefully considered the processes filed, the evidence adduced, and all the exhibits. On issue 1, which centers on whether there is an employment relationship between the claimant and the defendant, the claimant pleaded in paragraph 11 of his statement of facts that he, alongside others, worked as a team for 6 months. They were not paid, but it was on the 3rd month that Nigerian Agent Oil Company Limited awarded the oil and gas surveillance job contract to the defendants to secure their facilities. The defendant pleaded in paragraph 3, 4, 5 of the joint statement of defense of the defendants that the first and the second defendants had a surveillance contract with the Nigerian Oil Agent Company Limited to secure its oil and gas pipeline, among other oil facilities, which job the first and second defendants executed through the use of the Nigerian military, security and civil defense corps, and the Nigerian police. That during the operation and execution of the aforementioned contract, one Mr. Levi Wilson was contracted every year with distribution of fuel, PMS, and engine oil into the speedboat used for the operation by Nigerian military, security and civil defense, and the Nigerian police. that Mr. Levi Wilson needed some boys to work with him in the distribution of the PMS, hence brought Mr. Samuel Uku and Mr. Godwin Gideon to help him turn the fuel into the speedboats, while the third defendant brought in Mr. Odi Leon and the claimant being his younger brothers to assist Mr. Levi Wilson for a monthly allowance. Now, it is deducible from the fact of this case that there is a sort of employment relationship between the claimant and the defendants, though without a letter of employment. Section 90 of the Labor Act provides that a contract of employment means any agreement, whether oral or written, express or implied, whereby one person agreed to employ another as a worker and that the other person agreed to serve the employer as a worker. In the case of Agoma against Guinness Nigeria Limited, citation provided, the Supreme Court held that to establish a contract, whether be it express contract or a contract implied by law, there has to be a meeting of the minds of the parties within a definition of the contractual terms reasonably clearly made out to affect the legal relationship. And this is what is called the consensus of Adide in the law of contracts. From the totality of facts of this case, there is an employment relationship between the claimant and the defendants, though counsel for the defendant argued that failure of the claimant to tender a letter of employment is fatal to the case of the claimant. The defendant cited the case of Luke Guard Limited against Adariku and others, reported in 2022, LPELR 59331, a court of appeal decision. The fact, let me state here that the fact of this case in Luke Guard Limited against Adariku and other Supra can be distinguished from this instant case at hand. In that case, there was no formal letter of appointment or contract or any other written memorandum, however described, detailing their conditions or terms of employment, was never given to the claimant or published on a board or any other medium for them to access the same, and the claimants got no wages or any sort, and defendant in that case denied ever employing the claimant. While in this case, there is abundant evidence before that the claimant worked for the defendants and the defendants paid salary to the claimant. In paragraph 6 of the joint statement of defense, the defendant stated that the claimant, Mr. Samuel Ugu, and Godwin Gideon and Odi Leon were all told their allowances and they will only be engaged during the period of the first and second defendant's contract, Nigerian Ajib Oil Company Limited. And they are all placed in this, they are placed on salary, the sum of 70,000 naira only on monthly basis. Though there may be a dispute as to the amount of the salary the claimant received from the defendants, but that should not be a reason to conclude that there is no contract of employment between the claimant and the defendants. In the case of Efuribe against Uba, reported in 2010, the Supreme Court, while commenting in the case of B.A. Morofula against Kwara State College of Technology, the Supreme Court held, and I quote, "It will be seen from the above dicta that it will not be right for a trial court, as it happened in the instant case, to imagine that Morofula's case, Supra, merely decides that a plaintiff action for termination of employment must be necessarily failed where the plaintiff has not produced his letter of employment. To the contrary, the decision of the Supreme Court in Morofula's case turned on inefficiency of pleading to sustain the claims of the plaintiff appellant. Furthermore, the fact that Morofula's case was decided on these peculiar facts and did not lay down a general rule that the inability of a plaintiff to plead or tender his letter of employment automatically leads to the dismissal of his case has been recognized in cases decided after the Morofula's case. Thus, in NIIA against Mrs. T.O. Ayamfam, reported in 2007, 7 NWR at 271, Salam JCA drew out an important distinction where my Lord stated, and I quote, "Generally, the letter of employment must be resorted to in considering and determining the rights and obligations of the parties. Where the plaintiff fails to plead and prove the fact of his appointment in a contract of service, he will not be entitled to the declaration that his appointment succeeds." Morofula against Kwara State College of Technology. But whereas in the instant case, the appellant admitted the existence of the contract and the conditions of service was put in evidence, the rigid rules set down in Morofula's case, Supra, will not be adhered to. Unquote. Given the admission of the defendants that the third defendant brought in Mr. Odi Leon and the claimant being his younger brothers to assist Mr. Levi Wilson for a monthly allowance, it is sufficient to establish the employment relationship of the claimant and the defendants. It is therefore the finding of this court that there is an employer-employee relationship between the claimant and the defendants, and I so hold. Lest I forget, the claimant stated in paragraph 6 of his reply that he was being paid the sum of 750,000 naira monthly as a salary. The defendant pleaded that the claimant, Mr. Samuel Omu, and Godwin Gideon and Odi Leon were all told their allowances and they would be engaged during the period of the first and defendant's contract with Ajit Oil Company Limited. And they were placed on the sum of 70,000 naira only as monthly allowance, and each allowance where the claimant was given additional 680,000 naira only monthly to be given to family members of the claimant and the third defendant. The rejoinder of the defendants as to the amount the defendant paid the claimant disputed, and it is deemed admitted. An averment that is not responded to or controverted are deemed admitted. See the case of Husseini against Attack, reported in 2023 at NWLR Part 1887 at page 519. Even at that, there is nothing before this court to conclude that the defendants paid the claimant the sum of 750,000 naira monthly as a salary. Though a subpoena witness of the claimant brought UBA bank account statement of the claimant, the said bank statement of account was not tendered in evidence, and the court cannot rely on it, having not been tendered in evidence. Section 192 of the Evidence Act merely authorizes a subpoena duces tecum to be issued to a person to deliver a document to the court, either personally or through any other person he may consider suitable for the assignment. Once such a document is delivered or caused to be delivered to the court, the person's obligation is discharged and he cannot be sworn or cross-examined. But the delivery of the document in court pursuant to Section 253 of the Evidence Act 2011 as amended does not relieve the person, that is the claimant, who summoned a person to produce a document, the burden of proving the document, by having it admitted in evidence by tendering it, though a person, through a person who can do so. See the case of INEC against Action Congress. In the case of Pamakiwa against University of Ibadan, the Court of Appeal held, and I quote, a person who brings forward a document cannot be said to have been given it in evidence, not to talk of his having capacity to give or tender it in evidence, particularly when the person served with subpoena duces tecum has the option or liberty to cause it to be producing, but through any other person of his own choice. It is therefore my firm view that Section 192 of the Evidence Act merely authorizes a subpoena duces tecum to be issued to a person to deliver to the court or document either personally or through any other person he may consider suitable for the assignment. And once such a document is delivered or caused to be delivered to the court, the person's obligation is discharged and he cannot be sworn nor cross-examined. But the delivery of the document in the court in pursuit of Section 192 of the Evidence Act does not relieve the person who summoned an adverse party to produce a document of the burden of proving the document by having it admitted in evidence by tendering it to a person who has capacity to do so, unquote. Thus, the UBA bank statement of account produced by the subpoena witness is of no use and worthless document like a used sanitary pad. Given the foregoing, EC1 is hereby resolved in favor of the claimant to the extent that there was an employment relationship between the claimant and the defendants, and I so hold. On EC2, which borders on the unpaid accumulated salary of the claimant, the claimant pleaded and laid evidence to state that after opening the individual accounts, he started receiving his monthly salary from the second defendant through his individual bank account, domiciled with the United Bank for Africa, UBA PLC, till April 2020, when he has not been paid his monthly salaries without any form of notice or explanation or reason given. In defense of the averment of the claimant, the defendants pleaded that the claimant, Mr. Samuel, Mr. Godwin Gideon, and Odi Leon were all told about their allowances, and they will only be engaged during the period of the first and defendant's contract with the Nigerian Oil Agent Company Limited. That is when their contract was terminated by the Nigerian Agent Oil Company Limited, the claimant and others stopped receiving their monthly allowances. The averment of the defendants is further strengthened by evidence of DW under cross-examination, where he stated that Mr. Levi Wilson told them that it is a contract, and once the contract ends with Nigerian Agric Oil Company Limited, then the casual work ends. He was told that the contract had ended and he left. Again, DW3 also said under cross-examination that he did not have any document to show when the said contract between the defendants and Nigerian Agric Oil Company Limited was terminated. But the contract was terminated on the 20th day of March 2020. The third defendant came to the side and told the workers about the termination of the contract. What is more, the evidence procured from cross-examination is as valid and authentic as evidence procured under examination chip. But they have the potency of relevancy, which is the heart of admissibility of evidence. Where evidence is relevant, it is admissible and admitted, whether it is procured from under examination chip or cross-examination. So evidence elicited from the cross-examination of a defense witness, which is aligned with the facts pleaded by the plaintiff, forms part of the evidence produced by the plaintiff in support of facts pleaded in the statement of claim and can be relied upon in proof of facts in dispute between the parties. See the case of MTN Nigeria Communication Limited against Corporate Communication Investment Limited. Section 9 of 7 of the Labor Acts provides, and I quote, a contract shall be terminated, A, by expiration of the period for which it was made, B, by the death of worker before the expiration of that period, or C, by notice by Section 11 of the Act, or in any other way in which a contract is legally terminable or held to be terminated, unquote. Given the nature and the circumstance of the employment of the claimant by the defendants, the employment of the claimant with the defendants terminated upon the expiration of the surveillance contract of the defendant, Nigerian Oil Agric Company Limited. Upon termination of the surveillance contract of the defendants with Nigerian Agric Oil Company Limited, the employment of the claimant has come to an end, and the claimant cannot expect to receive his acclaimed or paid accumulated salary from the defendants afterwards. Finally, for this reason, the C2 is hereby resolved in favor of the defendants, and I so hope. On the whole, for all the reasons given ab initio, the claim of the claimant fails, all the relief thought are refused, and the case of the claimant is hereby dismissed accordingly. I make no order at cost, and judgment is hereby entered accordingly.
My Lord, we are very grateful for the well-considered judgment of this court. We are very grateful, my Lord.
Thank you.
But we are also grateful for the judgment of the court.
Thank you, Agnes.
Case number 4, NICS/Yenagoa/13, 2022, between Dr. Mba Okechukwu Abu and Nigerian Delta University.
Yes, appearance. Appearance. Nobody in this matter. Dr. Mba Okechukwu Abu. Nobody.
Yes, I'm present, sir. I am present, my lord.
The claimant present.
Yes, sir.
Appearance, any legal representation. Claimant not represented, defendant not represented. This is a judgment of the court. The claimant commenced this suit by way of complaint filed on the 23rd day of May 2022 under Order 3, Rule 2 of the National Industrial Court of Nigeria Civil Procedure Rules 2017, wherein the claimant claims against the defendant the following reliefs. a declaration that his purported dismissal from the service of the university, where the letter with reference number NDUREG/SUSP volume 2104 dated 28 February 2018 is null and void. Secondly, a declaration that he is still a lawful employee of the Niger Delta University NDU by virtue of his terms and conditions of employment. And thirdly, an order of reinstatement as an employee of the defendant's institution. The claimant predicated his claim on the statement of facts and witness statements on oath filed on the 23rd day of May 2022, and reply on a further witness statement on oath filed on the 2nd day of November 2022. The defendant based its defense on a statement of defense and a witness deposition of oath filed on the 9th of November 2022. At the preliminary hearing on the 20th day of July 2022, where the claimant called the first witness, the claimant who testified for himself, hereinafter referred to as CW1, identifies his deposition made on oath on the 23rd day of May 2022 and 2nd day of November 2022, and adopted the same as his evidence in support of his case. The claimant thereafter tendered exhibit CW001, CW002, and CW003. On the 11th day of October 2023, the defendant opened his defense. Mr. Benjamin Joffa, hereinafter refers to as DW1, testified for the defendant. DW1 identified his statement of oath filed on the 9th day of November 2022 and adopted the same as his evidence in support of the defense of the defendant. DW1 thereafter tendered exhibits NDU001 to NDU004, A to D. After the close of the hearing of the suit, on the 4th day of December 2023, the matter came up for adoption of final written addresses filed by counsel. Counsel for defendant identified his final written address filed on the 16th day of November 2023 and adopted same as his legal submission in the aid of the case of the defendant and urged this court to dismiss the suit. Counsel for the claimant identified his final written address filed on the 17th day of November 2023 and adopted the same as his legal submission aid of the case of the claimant, while urging this court to grant the claim of the claimants. Let me briefly state the case of the claimant in brief. The case of the claimant is the purported dismissal of the claimant as a lecturer in the Department of Business Administration of the institution, where the purported dismissal letter is reference number NDUREG/SUSPP 2104, dated the 28th day of February 2018. That he was engaged as a full-time lecturer in the Department of Business Administration in 2010 or thereabout, where the letter of appointment as a senior staff dated 18th May 2010, that he has worked or performed his duties diligently without blemish since his employment and completely enumerated and appreciated by the defendant until the unfortunate incident leading to his purported dismissal. That his purported dismissal is predicated upon the alleged unauthorized publication and sale of a book titled Principles and Practice of Entrepreneurship for Economic Empowerment to students in the institution. That he has the consent and authority of the defendant through his faculty to publish the said book in aid of teaching and research, which is his primary obligation as an academic. That upon the publication of the book, he caused the same to be displayed on bookshelves in bookshops outside the defendant institution, where students purchase same for use. For use in aid of their studies and research. That he did not personally sell the book to students of the institution at any point in time, nor did he make the purchase of the same as condition precedent by student, either to sit for his courses, tests, or any other academic requirement in the course of his employment. That he was rather taken aback to be invited to appear before the defendant senior staff disciplinary committee for an alleged case of unauthorized sale of a textbook, typing the purchase of the said textbook as a condition, buying the purchase of the said textbook as a condition precedent for student writing courses tests in disregard to constituted authority. That the invitation to appear before the said committee was verbal and communicated to him by the dean of his faculty, which he promptly complied with. That it was during his appearance before the committee that he learned of the alleged offense of unauthorized publication, sale of the textbook, and also compelling students to purchase same as petition president writing tests in courses he was handling, which the claimant vehemently denied the said allegation in his defense during the meeting, wherein he was discharged and home to await the outcome of the committee's decision on the matter, that he was rather surprised to receive a letter purportedly dismissing him from the service of the defendant's university. Now, upon the receipt of the said letter, he wrote 2 letters to the governing council, the defendant's university, asking for a reconsideration of its decision. That despite the receipt of the said letters, the defendant did not respond to his plea. Positive or otherwise, to date. That after waiting for over 2 years for his response, despite using 3 parties to intervene also on his behalf, which did not have any effect, he was compelled to seek the services of a solicitor who wrote a letter to a defendant, Niger Delta University, complaining about his unlawful dismissal. That the defendant is yet to acknowledge or respond to the letter stated above in paragraph 18 of the statement of fact hearing until the institution of this suit. That he said he has suffered mental, physical, psychological, and economic hardship and trauma by the act and omission of Niger Delta University in the suit. Let me briefly state the case of the defendant in brief. The defendant in its rejoinder stated that the claimant was and has been a person of questionable character even before this incident, which precisely the 30th day of July 22. He was caught selling an unauthorized book to students and was queried and suspended from duty. He was made to face the Senior Staff Disciplinary Committee, SSDC, but arising from his show of remorse and the magnanimity of the defendant, he was forgiven, recalled from suspension, and was warned. The defendant never at any time granted claimant consent or authority to produce a book called Principles and Practice of Entrepreneurship or Economic Empowerment, or any other book whatsoever in any form. That the claimant did what the claimant did in line with his usual character by producing the book on his own accord and selling it to students, as rightly stated by him, that he caused the book to be displayed on bookshelves in the bookshop outside the defendant's institution, precisely at the gate of the school, where students were meant to go and purchase. He did this in disguise to avoid being caught. That the claimant made the purchase of the said book a condition precedent, text, or continuous assessment. The claimant was properly queried on the allegation on the 8th day of September 2015, which he responded to on the 10th of September 2015. Thereafter, he was suspended on the 17th day of September 2015 and was made to face the Senior Staff Disciplinary Committee, SSDC, which culminated in his dismissal having been found liable. That before the query, the claimant was apprehended by the security department of the university, and he made a voluntary statement admitting the allegation. The defendant denies that the invitation was only verbally communicated to him as shown in the suspension letter. The formal invitation was served on the claimant through the dean of his faculty, since he was already not within the university premises anymore, arising from the suspension. So he was well served with the invitation containing the allegation before his appearance. That after hearing from him, the other witnesses, he was found liable by the committee. Hence, the letter of dismissal should not be a surprise to the claimant that he was properly so dismissed. After the close of this matter, counsel for the claimant nominated 2 issues for the termination of this. That is, whether or not the claimant has proved his case on the preponderance of evidence to entitle him to the relief he seeks in this suit. And secondly, whether or not the claimant was afforded a fair hearing by the defendant before his purported dismissal. Counsel for the defendant submitted 3 issues for the determination of the suit, which A, whether the claimant is entitled to relief thought having failed to prove his case, B, whether the action of the defendant was lawful, and C, whether the claimant was given fair hearing. I have carefully studied the case of the claimant, the defense of the defendant, and their respective written submission. I suppose the issue raised by the claimant is conscious and all-encompassing to cover issue 2 raised by the claimant and the 3 issues raised by the defendant. I hereby adopt issue 1 raised by the claimant as the issue for the determination of the suit. For the avoidance of doubt, the issue for the determination of this suit is as follows: whether or not the claimant has proved his case on the preponderance of evidence to entitle him to the relief he seeks in this suit. I will skip your submissions and I will go to the decision part of this judgment. After a careful analysis into the evidence adduced by parties, The position of the law has always been that he who asserts must prove. Thus, since a claimant normally asserts the existence of certain facts, he must prove those facts if he is desirous of succeeding in his action. The burden of proving his case lies with him and never shifts till he has discharged the bonus placed with him by the court. See the case of Adeleke against Balo and Section 131 of the Evidence Act 2011 as amended. In doing so, a claimant is to succeed on the strength of his case and not on the weakness of the defense. See the case of Cargill Ventures Limited against Postal Services Nigeria Limited. The claim of the claimant revolves around his dismissal by the defendant as a lecturer in the Department of Public Administration of the institution, via the dismissal letter, the reference number NDURG SUSP 210, dated 28th day of February 2018. That this purported dismissal is predicated upon the alleged unauthorized publication and sale of a book titled Principles and Practice of Entrepreneurship of Economic Development to students, the institution, that he has a consent on authority of the defendant through his faculty to publish the said book in the head of teaching and research, which is his primary obligation as an academician. The claimant tendered CW002, which is a dismissal letter from the service of the university in evidence as exhibits. That upon the publication of the book, he caused the same to be displayed on bookshelves in bookshops outside the defendant institution, where students purchased same for use in aid of their studies and research. And he did not personally sell the book to students of the institution at any point in time. Nor did he make the purchase of same as a condition precedent by student, either to sit for his course, his test, or any other academic requirement in the course of his employment. That he was rather taken aback to be invited to appear before the defendant's senior staff disciplinary committee for an alleged case of unauthorized sale of textbook. Buying and the purchase of the said textbook as a condition precedent for student writing course tests in disregard to the consulting authority. The invitation to appear before the said committee was verbal and communicated to him by the dean of his faculty, which he promptly complied with. The defendant, in their defense, stated that the claimant was and has been a person of questionable character even before this incident started the day of July 22. That he was caught selling an unauthorized book to students, was queried and suspended from duty, was made to face the senior staff disciplinary committee, but arising from show of his remorse and the magnanimity of the defendant, was forgiven. He called for suspension and responded. The defendant never at any time granted the claimant consent or authority to produce a book called Principles and Practice of Entrepreneurship of Economic Development or any other book whatsoever in any. The claimant did what the claimant did in line with his usual character by producing the book on his own accord and selling it to students. The claimant made the purchase of the said book a condition precedent for sitting of continuous assessment. The claimant was properly queried on an allegation the 8th day of September 2015, which he responded. Thereafter, he was suspended and he was made to face the committee, which culminated in his dismissal, having been found guilty. I had a crucible study of the case of the claimant. The claimant did not, through his pleading, challenge the proceeding of the senior staff disciplinary committee of the defendant, which led to a dismissal from the service of the defendant, except where the claimant stated that he has the consent and authority of the defendant through his faculty to publish the said in aid of teaching and research, which is his primary obligation. As an academic, the invitation to appear before the senior staff disciplinary committee of the defendant was verbal and communicated to him by the dean of his faculty. Let me make it clear that the business of this court is not to meddle into the decision of the defendant, but rather to determine whether the decision reached by the defendant complies with the laid down rules of fair hearing and condition of service of the defendant, if any. Let me make it clear. By way of reviewing the proceeding of the senior staff disciplinary committee of the defendant, which led to a dismissal from the service of the defendant was issued a query. The defendant was issued a query dated 8th day of September 2015, which is tendered as exhibit NDU 004 on the following grounds. 1. You sold your book titled Principles and Practice of Entrepreneurship or Economic Empowerment at a price of 3,000 naira without authorization. Secondly, you tied the purchase of the book as a condition for writing your post-test. Unquote. The claimant responded to the allegation via exhibit NDU-004B and denied the allegation. Defendant found the response of the claimant unsatisfactory. The claimant was suspended and his case was referred to Senior Staff Disciplinary Committee of the defendant. Defendant found the response of the claimant in exhibit NDU-004A unsatisfactory, given the undertaking made by the claimant via exhibit NDU-003 with the Security Department of the defendant. All this happened before the claimant appeared before the Senior Staff Disciplinary Committee of the defendant. Hence, the claimant cannot feign not having the knowledge of the allegations against him before appearing before the Senior Staff Disciplinary Committee of the defendant. Also, the claimant appeared before the Senior Staff Disciplinary Committee, the defendant. The committee recommended that the claimant should be dismissed from the service of the defendant. This is contained in exhibit NDU-004. Gleaning from exhibit NDU-004A, NDU-004B, 004C, and D, the claimant was afforded a fair hearing, if at all they complain about the fair hearing. In the case of Miden System Limited against APION, the Court of Appeal held, I quote, the principle of fair hearing entrenched in the Constitution is so fundamental in the judicial process or the administration of justice that a breach of it in any proceeding vitiates only the all proceedings. It must be made clear that a proceeding conducted in breach of fair hearing, no matter how well conducted, is null and void. The breach of fair hearing is such a fatal virus that irredeemably vitiates any proceeding which it imparts right to fair hearing, and as such it is set aside. Quote, throughout the proceeding of the Senior Staff Disciplinary Committee of the defendant, the claimant was offered a fair hearing, and the claimant did not in his pleading complain that he was not afforded a fair. The fair hearing as a fundamental procedure is sine qua non in all proceeding before judicial or quasi-judicial bodies like the Senior Staff Disciplinary Committee of the defendant. See the case of Muideen against Nigerian Bar Association, reported in 2021, 13 NWLR Part 1794 and 390. The claimant does not challenge the proceeding of the Senior Staff Disciplinary Committee of the defendant. Surprisingly, counsel for the claimant came out of the blue in his final written address to challenge the proceedings of the Senior Staff Disciplinary Committee of the defendant, to say that the dismissal of the claimant is not in compliance with the conditions of service of the defendant. The claimant did not, by any share of imagination, challenge the dismissal of the claimant on any ground. Neither did the claimant plead or tender the conditions of service copiously referred to by the counsel for the claimant. The claimant did not plead any conditions of service, which the defendant did not follow in dismissing. Neither did the claimant tender any conditions of service. The claimant copiously, in his written address, referred to the condition of service of the defendant, which was neither pleaded nor tendered in evidence. In the course of UBN against Chien, the Court of Appeal held that the burden of proving the civil matter lies with the person who would fail if no evidence at all were given on either side. In the instant case, since it was the respondent case that the termination of his employment by the appellant was wrongful, null and void, for not being in tandem with the terms and conditions of the contract of service between them, it was squarely left for him and not the appellant lead and prove the conditions of service in question and in what way the terms were not properly observed. The respondent failure to tender the conditions of service rendered this abandonment barren and empty. It is a bad advocacy skill to use the final written address of counsel to change the character of a case of parties. It is akin to stealing the match from the adverse party. The foundation of the case of the parties is squarely on pleadings and evidence before the court. The court can dispense with the argument of the parties on issue of fact, but the court cannot do justice to the case of parties without placing its reason and findings on the pleading and evidence presented before the court. The Nigerian adversarial system of justice, matters are decided based on pleadings and evidence after issues has been joined by parties. It is the evidence presented before the court that is used in deciding on the dispute between the warring parties. See the case of Airtel Networks Limited against George. The address of counsel, no matter how brilliantly and erudite, cannot take the place of pleadings or evidence on record. as the issue merely raised by counsel in its address cannot be part of the evidence before the court, ought to be discountenanced. See the case of Andrew against INEC. The case of the claimant is bound to fail for the reason that the claimant does not, by his pleading and evidence, challenge his dismissal from the service of the defendant on any ground. The claimant was afforded a fair hearing, and this court will not disturb the decision of the defendant, having found that the claimant was afforded fair hearing. And lastly, the argument of the claimant via this final written address that the dismissal of the claimant from the service of the defendant is not in compliance with the conditions of service of the defendant is too belated to consider, having not been placed in its pleading. Flowing from the foregoing, the law is for determination of this suit is resolved against the claimant and in favor of the defendant. The case of the claimant is hereby dismissed for being destitute of merit. Parties are to bear their respective costs, and judgment is hereby entered accordingly.
My Lord, we are most grateful. First, I want to say that sorry I could not enter my appearance because of technical issues on my end. So sorry about that.
Yes.
Second, my Lord, I want to thank this court for the industry put into this judgment. We are most grateful. We are always learning from your wealth of experience. Thank you, my Lord.
Oji Apabra, thank you.
Yes, my Lord.
So that's all?
Yes, sir.
So I rise.